So first off, thanks everybody for joining me this afternoon. I've got a ton of information. FDA is sort of a mile a minute. Of course, all the states have different things that are happening. I can't speak to every single state. Of course, at the end or during, if you have questions, feel free to ask. I'm going to be talking about FDA first, looking at ENDS electronic nicotine delivery systems, all the products at our show. Then I'll be talking a little bit about the CPSC, the Consumer Product Safety Commission. They just came out with something related to packaging and liquid nicotine. And then I'm going to look at FDA and cannabis with respect to things that humans consume. Again, my name's Deanna Clark-Esposito. And my law firm, we help vapor industry companies comply with FDA laws on vape products, CBD and tobacco products, U.S. customs issues related to imports and tariffs. I also plan to talk a little bit about that as well, because we all got hit, with the prior tranche, they're called. And then also the Bureau of Industry and Security and the Office of Foreign Assets Controls with respect to exports, among other laws. I'm also on the board of directors of the Smoke-Free Alternatives Trade Association. And I have actually something that I wanted to announce. An email had come around on the 21st for manufacturers. How many of you are manufacturers in the room? Anyone? Okay, how about retailers? Okay, so of course, we all work together. All the manufacturers talk to you guys. You have your sales people you talk to, and then the manufacturers. Tell your manufacturers, okay, what SFATA is trying to do is here's what's going on. The North American E-Liquid Standards Summit is happening in June, and SFATA has sent a message out to manufacturers saying, hey, we'd like you to come to this meeting in Los Angeles because we want to talk about what's considered good manufacturing practices. We've actually been waiting for FDA to come out with good manufacturing practices. I mean, it's been 3 years since the deeming rule came out. That was when FDA said, okay, these products can stay, no other products can come onto the marketplace. They still haven't given us the guidance that we need. So, to the extent that manufacturers, it's important that you let them know that SFATA has made a call for manufacturers to attend the meetings June 18th and 19th in Manhattan Beach, California. And I can, forward this email to you. But the idea is to discuss standards and the development of an aligned North American proposal. And what that means is that Canada has come and said, hey, we want to put together a set of standards. And they did this with one of the people that started EMSA. That's I think it's the American E-Liquid Manufacturers something association. And so some manufacturers had been following those. Where the industry has its own set of standards, FDA is required to consider those. So because Canada has come and said, hey, let's figure this out, we want all the buy-in from our US companies as well. So if you hear of, or if you know manufacturers, and believe me, this is super important that they get involved, please come talk to me. I'd be happy to forward you the email. All right, so the disclaimer, this presentation doesn't reflect the opinions, beliefs, attitudes, or positions of either my firm, the Clark-Esposito law firm, or the Smoke-Free Alternatives Trade Association, and nothing in this presentation should be construed as providing legal advice, nor is that of creating an attorney-client relationship. And some of you smile, but believe it or not, sometimes people actually think, oh great, she's my lawyer. I'm happy to be all your lawyers, but we have to, have a formal arrangement, so. Anyway, so I mentioned I want to talk about FDA updates. And so, here's what's going on. And it's a little crazy because in March, they announced that they want to have this new compliance policy on vape products. And when they say vape products, they're referring to what they call electronic nicotine delivery systems, which I'm going to call ENDS. So in that proposal, they wanted to move up the date for what's known as the PMTA. The PMTA is the pre-marketing tobacco application, which products, all the e-liquids, the devices, everything downstairs has to undergo this application. And it has to undergo this application in an attempt to obtain authorization by the FDA, which is called a marketing order. So we had the date pushed back from last year, actually, to 2022 for non-combustibles. So cigars, et cetera, those 2021, vapor products, 2022. Now, under this new proposed compliance policy, and they gave all of us an opportunity to submit comments, and SFATA submitted comments, several companies and individuals submitted comments as well, because quite frankly, 2022 even isn't enough time given everything that they want in this application, which includes clinical studies, for example. And even they admitted in their own, they have been doing their own clinical study called the PATH study, and it's taking several years to do, and it's still not complete. In any case, because they want to push up the date by 1 year, it's effectively cutting off 1 year for the industry to file these applications. So all the manufacturers downstairs are subject to this requirement. And the reason why they're saying that they want to change their compliance policy has to do with the youth issue. And I live in New York. I see on the news this county, that county. Oh, high school students are juuling, actually. So I know from talking to other vape shop owners, I know from talking to my own clients, everybody actually has very good age verification procedures. Everybody does have some protocol. I know also, from perusing the FDA warning letters that come out on a weekly basis. It's 7-Eleven again, it's a convenience store again. There's sort of who's not paying as much attention versus the who are. And the vape industry, vape shop owners are the ones who are paying attention. So in any case, with this compliance policy, FDA intends to look at what they consider new tobacco products. And that just means those which hadn't been in the marketplace as of February 15, 2007 in the US marketplace. So that's our entire industry as far as they're concerned. So it includes e-liquids, e-cigarettes, cartridges, tanks, mods, etc. And they're looking at products that are flavors other than tobacco, mint, and menthol. Right? So looking at the Tobacco Control Act itself, so it requires that in order to lawfully sell, you must obtain the marketing order from FDA for the specific product in advance of any marketing or sales. And you have to understand, when they say for a specific product, they mean a certain bottle size, a certain nicotine level, or zero nicotine, with a specific SKU. And so when you're talking with your manufacturers, or for those of you who are manufacturers, when you did your product listing with the FDA, which had been due, I guess, a couple of years ago now, every single SKU got listed, and so those products are registered with the FDA, and there aren't supposed to be any product changes whatsoever, including the shape of the bottle. There are a couple of sections, labeling, of course. If you have child-friendly labels and you change those, that's fine. If you're pulling things off of the market, you report that, that's fine. And reporting to FDA happens twice a year, once during the month of June and once during the month of December. But while nobody has a marketing order in terms of the companies, sales are currently permissible because FDA has put its enforcement on hold, and they refer to that as a stay. So they have stayed or put on hold their enforcement for products which had been in the US marketplace as of August 8th, 2016. And this is the date that people refer to as the deeming rule or the deeming date. So since technically under the Tobacco Control Act, none of the ends, nothing downstairs, nothing in any of the shops may lawfully be sold since none have obtained a marketing order. The only reason anything can be sold is because they've decided not to enforce the law. So in looking at, again, this March proposal for their new compliance policy, they said, okay, we're going to do the following, because they wanted to take a sort of a priority look at how they're going to police the marketplace, and specifically how they want to remove products from the marketplace. So they want to target flavored ends products that are flavor other than tobacco, mint, and menthol, which are offered for sale in ways that pose a greater risk to minors to access such products, as well as for which no PMTA has been submitted by a manufacturer until before August 8, 2021. And I use the word submitted here because they went ahead and said, as part of their update, the 2017, what they'd done in 2017, where they extended the dates, they said, in addition to the extension, once it's been submitted, we'll also allow you to continue selling the products until we make a decision on yes or no for all of the products that you've submitted the application for. So products can remain on the marketplace, could be several years before they come down to a decision. This proposed policy also intends to target ends that are likely to promote the use of ends by minors or actually targeted to minors. I was at a show recently in New York, and I was walking it with a client who was shopping for their store, and they continually like, I can't believe that. Oh my God, look at that. Oh my God, look at that. Because it was, cartoon characters or something akin to like a Fruit Loops or a Rice Krispies, some kind of design, which the FDA certainly considers, kid-friendly or targeting, towards children. They're also targeting products sold in locations where minors can enter at any time of day. So that would be a convenience store. They're also targeting products sold in retail establishments or online locations where minors have been known to successfully purchase from. And I can tell you, I've gone and looked at sites, and even if the box pops up, like to put your age in or to verify, if I simply click outside of the box, then I can enter anyway. And kids are buying online. It's just what's happening, and we all know it. So, this is how they're looking at prioritizing their enforcement. They're also looking to target products sold where there's no cap on the quantity which may be purchased within a given period of time. So again, online, you just buy as much as you want. And it's interesting because I know from talking with some of the larger online retailers, people want to buy in bulk, and I don't actually think there's anything wrong with that. But then when you take the FDA perspective, if adults who are trying to quit smoking are buying in bulk, then, because there's no default mechanism, since they've done their age verification, at least on that front panel where you've got to put in your age, your date of birth, then minors can get to it too, But I understand the bulk shopping aspect as well. But that's what FDA is looking to target. They're also targeting products sold in locations where there's no independent age verification service, which could compare customer information against third-party data sources. And then, of course, the FDA continues to target products which haven't been listed with the agency at all. In fact, I had a client who reached out to me, and they sent me a warning letter that had been received by one of their manufacturers for a product that hadn't been on the market, but now is on the market. And so we were talking through, they're like, okay, what do we do? So this warning letter wasn't okay, you're prohibited from selling this. It was, send us information to prove it had been in the market in advance of August 8, 2016. So, when I talked about it with my client, I said, look, you still have inventory. It's still not banned. And this it's still not banned. If you feel comfortable continuing to sell it because it's not yet prohibited, that's your business decision to make. If you want to take your existing inventory, return it to them and ask for your money back, you can do that too. They sell other products, so presumably they want to keep the client relationship with this purchaser. And then, of course, we need to follow up. So all suppliers, we've implemented in terms of retailer due diligence, is we have supplier questionnaires that you send out to the suppliers. Maybe you order a small batch at a trade show, because you want to try it out and see if your customers even like it. But then when you move forward, you want to place an order. You've got to give them their questionnaire. Find out what's registered. Find out if there's been any warning letters. Find out if they're a problematic company. Find out if they're honest, right? I mean, there's a lot of things that go into the questionnaire. So you can make sure that you don't end up with inventory on your shelf so that when an inspector comes in, they're like, what, we've actually got to remove all of this. And then, you're, I'm trying to think of a phrase that's not colorful. You're not, no, can't say that either. Anyway, you're not in a bad place, all right? All right, so for retailers, if you're a retailer shopping for new products at your store, be sure to ask the distributor or manufacturer for documentation of their FDA registrations and the date it was done, so you don't find yourself with violative products on your shelf that you can't lawfully sell. You also want to ensure that your tobacco product retailer training program is up to date. Now, last year, FDA announced that they were going to be stepping up their inspections of retailers, both their underage cover buy, so where they come in and they hire youth to try and buy, along with just coming in and seeing what products are on your shelves. So you want to make sure your employees understand what to do. The undercover buy inspections, of course, are not announced, but other FDA inspections, which are not the undercover buys, are announced. So So you want to get their ID, you want to get a photocopy, you want to make sure you document what are they looking at, what did they take from the store, if anything, when are they going to follow up with you. I have a handful of a form that I created. It's an FDA inspection form, and I'd be happy to give those to you if you want to come up here after. Okay, next. So ensure you train your staff in the next 30 days, okay, to the extent you haven't done it recently, on age verification procedures and document that the training occurred. So just write up a sheet of paper, age verification training occurred on, or I attended, name of your store, age verification training on this date, and have them sign it and put it in their file. All right, this way you've gone over, because all of you who are retailers anyway will have, your age verification system that you use, or how you check ID, or if when you look at an ID, just to make sure it's not a fake, okay, what's your zip code? What's your address, right? You get the purchaser to double check that, it's not a fake ID. I know from hearing friends, talk about fake IDs when I was younger, that nobody knew the address or the zip code, so it's just another way to check, even though you're checking, but you check on top of that. You also want to ensure that your website's age verification protocol is in solid and working order, so you can't just click around it. That'll put you on FDA's, red flag it. And then go ahead and place a limit on your website of the maximum amount of purchases that can be made in a given time. Now, again, I know some companies don't want to do that at all, but we know that FDA is looking for companies who have no limit. So because of that, put a limit, have them by the next day, Now, in terms of manufacturers and importers, so you want to eliminate any marketing, including product labels, names, et cetera, that resemble kid-friendly foods or drinks, or other non-ENDS products that are often consumed by youth. So I mentioned the Rice Krispies or the Fruit Loops before. You also want to ensure that you know which FDA filings you needed to have made, and that you actually did make all of them. Some companies I know took the approach of, let's file everything under the sun because we have it and we haven't rolled it out yet, but it's available for us to offer in the marketplace. And that got registered before the deadline passed where you couldn't. I've had other clients, we've amended it, so it was after the date passed, but we sent in an amendment. To say, hey, these got missed, now we've got counsel, and after their review, we realized such and such. Some products were filed, but filed incorrectly. We can go back and correct those. So, just make sure what you needed to have done has been done, and to the extent those filings had been made, that you're only selling those products. And then lastly, you want to ensure that your FDA compliance manual is up to date and in existence, for those of you who don't have one. So retailers, you have a retailer FDA compliance manual, and you probably want to throw in your own state requirements into that. Manufacturers, you want to have yours as well. I was just in on a conversation relating to a visit by the FDA. All manufacturers, under the law itself, so not the regulations, but the actual law, requires FDA to come and inspect manufacturers who've registered their establishments every 2 years. Now, they're behind schedule. I know some companies, they haven't been inspected yet, and quite frankly, with this current administration, every agency's budget got cut, and FDA, of course, had to deal with a budget cut as well. But if you haven't been inspected yet and you're a manufacturer, you are on their list for inspection. And the first thing a government agency always wants is they want to see your written procedures, and they want to see that you are following them, which is why I mentioned earlier. If you're training your staff on age verification procedures, get them to sign a document you create, I so-and-so attended this age verification procedure. Signed, dated, because they want to know that you have procedures and that you're following them. And the only way they know that is by seeing something in writing. Yes?
Is that something that we, as a shop owner, a training that we create, or you're saying another training that is offered by like the county or something like that?
So the training is actually the responsibility of the shop owner.
Okay.
And
So it would just be whatever training the shop owner has, whatever training that they have in place that the staff member did.
It is. And actually, I'm offering So on one side, I've got top 10 best practices for a compliant vape retailer, but on the other side, next month, I'm offering a webinar, and if you use the code CHAMPS, you can attend for free. And it's going to talk about how to put together your retailer training program, actually, okay? So you just sign up. It's through Eventbrite, and you get the ticket and use the promo code CHAMPS, okay? Because I know retailers need this, and it's like, where do you get this information? So you'll get it, from my firm. All right, so for manufacturers and importers, all right, you want to ensure that you have a written plan with a timetable for the timely submission of your PMTA. And you want to go and review this, whomever you're using, whether it's just a third-party consultant or your counsel. You want to review that because it's highly likely that we're going to lose a year, and we're going to need to just do the best that we can and get those applications in. And with the year getting cut off, now we've got to accelerate what we're doing, okay? Also, manufacturers, you want to ensure that your website parameters are set the same as I just described for the retailers. Make sure that those are in effect. And then for any importers, you want to ensure that your foreign factory has its products listed with the FDA as well. All right, so just to throw a wrench into everything, last week we had a decision come out in a court in Maryland. The American Academy of Pediatrics versus the FDA, okay? So in this case, they challenged this 2017 guidance where FDA gave this extension. So they challenged the extension to 2022 for the non-combustible products from the original deadline of last year. And they challenged that FDA said we're going to allow these products to stay in the marketplace until a decision is made. So again, as I'd mentioned earlier, so in March, FDA announced this new policy on ends to move the date up. We're losing a year for the PMTAs, and then they're going to keep the grace period. So as long as you've got it submitted, the manufacturers have their PMTA submitted, they can go ahead and keep selling the product. So the position of the American Academy, they claimed FDA didn't have the authority to extend the deadline and also to allow the products to stay in the marketplace. They said that FDA can't authorize any of these products even being in the marketplace because none of them have a marketing order. And then third, that FDA can't merely announce a decision regarding the PMTA requirement without what's known as a notice and comment period, which is required for most rulemaking, is what it's called, under the way that we have administrative decisions, and FDA is an administrative agency. So they asked the court to vacate this guidance, which is highly unusual and not very common. Normally you have a regulation vacated, but the FDA, as I mentioned earlier, really hasn't come out with many regulations for us. Now, the FDA's position is that it has the authority to delay enforcement and to permit products to stay in the marketplace if they had been there, before August 8th, 2016, and to stay after, pending their decision. That's in their agency discretion. And normally the agencies have very broad discretion to do whatever they want to do. FDA's position was that its compliance policies can be changed under their discretion under this Administrative Procedure Act. So whereas the original date had been 2018, then they went ahead and extended it at their own discretion. They said it's okay for us to do that. And they want more time to figure out what the regulations are that they're going to create. And they also want to receive higher quality pre-market tobacco applications because the initial rounds coming in were so bad that they actually published a statement saying, here's when we're not going to accept your PMTA. In an effort to get them better organized. And things just included things like foreign language documents which hadn't been translated. I mean, they're like, well, we can't, deal with these, so we need, translations, et cetera. So the judge last week, they agreed with the American Academy that a notice and comment period should have happened with respect to the PMTA. And what was actually unusual about this case is normally when you have any case, quite frankly, and you are asking the court to do something, you're moving the court to do something, the attorneys have an opportunity to go and have oral argument before the judge. Your Honor, such and such, Your Honor, such and such, and here's why they're wrong. And you go back and forth, and the judge has an opportunity to hear the argument. In this case, The judge simply took the arguments laid out in the documents and came to a decision. And for such a big decision, because you have to appreciate, even though American Academy brought this, it still led to other organizations, companies submitting what are known as amicus briefs. These are friends of the court, friends who want to also provide their own opinion and position with respect to this. And they had several amicus briefs filed. And rather than allowing an opportunity for the attorneys to present their arguments, they just ruled. So they said that FDA abdicated its duty to enforce the Tobacco Control Act, and that FDA essentially rewrote the law when it came out with the deeming rule describing the PMTA. And so that the FDA went beyond mere discretion, like it was just overstepping its authority. Yes?
Is FDA going to appeal because that's judiciary stepping on the executive?
We don't know. So we don't know if they're going to appeal. Only FDA knows. He's going to appeal.
The drug industry and different industries, if they set it as precedent.
And so what he's getting at is the following. So FDA has this discretion, and if they decide that they're not going to challenge this judge's decision, then it can serve as a precedent in the sense of, well, separate from tobacco, they also have pharmaceuticals, they also have cosmetics. And where a judge wants to say, oh, you know what, you can't do this, if they don't fight this one, then that can be used against them essentially. I think this is what you're getting at, with respect to pharmaceuticals or cosmetics or drugs, you know, whatever the case may be. I'm getting there. So let's see here. The judges, so the judge went on to say, I'm still continuing with what the judge had decided, that FDA was not allowed to set the deadline for the PMTA so far out. So it felt like it was too much of an extension to 2022. It also said, though, that if companies are following the current guidelines, this draft guidance, then they consider, this judge anyway, considers a company to be in compliance. But the judge went ahead and vacated that 2017 guidance that extended the PMTA deadline. And then it ordered the American Academy of Pediatrics to submit what it thinks should be a final remedy, which is also a bizarre thing to do. And then, so FDA has 60 days to appeal this decision. So, you know, this literally happened last Wednesday. So we don't know what FDA, you know, is going to do. But of course, it's like, well, where does this leave us? Because there's lots of unknowns at this point, since we don't know what the FDA is going to do. FDA may not want to risk, you know, an appeal. They may want to use this decision as an excuse not to help the industry. Even if FDA came out with a new rule, a new guidance, that can be challenged by the industry. It can be challenged by other interested parties. So at this point, you know, really kind of everything is again up in the air, kind of. So what should industry do? So FDA recognizes, and they acknowledge this even in the deeming rule, that vaping is helping former smokers move to a healthy alternative than cigarettes. So they've acknowledged that. I saw Mitch Zeller was speaking at a public health conference at New York University last fall. And so Mitch Zeller is the director of the Center for Tobacco Products at the US FDA, Food and Drug Administration. So he was explaining how the challenge that the agency has is balancing what they describe as the off-ramp for smokers with respect to cigarettes versus the on-ramp for primarily youth, is who they care about, because they're concerned about creating a generation of new nicotine. It always boils down to being addicted to nicotine, okay? And the way FDA describes nicotine consumption in general is they call it this continuum of risk. And this continuum has cigarettes on the most harmful end, and then on the least harmful end, other than not smoking or doing anything at all, like the nicotine patch. Those are their modified risk tobacco products, right? So somewhere in there, he said, falls vaping. And they don't know because there hasn't been enough time for scientific studies. And of course, we all know that there have been plenty of studies outside of the United States, but that when FDA comes to making its own decision making, it relies on studies conducted within the United States. So of course, that's another, you know, hurdle that we have. So FDA does recognize that vaping is helping, you know, former smokers move to a healthier alternative. So, I mean, the outlook from sort of talking to other folks in the industries, we don't see the FDA shutting down the industry, especially in light of their new compliance policy, where they were specifically talking about how they're going to do their enforcement and prioritize their enforcement. But of course, we don't know. So, everyone in the room, of course, we should all continue to operate in compliance as best we can. Manufacturers, you want to make sure your products are registered. You want to make sure you're only selling those registered products. You want to send in your biennial updates. So again, if you change the label, for example, earlier, I think it was in March also, FDA announced that e-liquids no longer need to have what percentage of nicotine is foreign content, whereas that had been required before. So now if you update your label to remove that kind of a change, you'd report, to the FDA. So biennial, that means June or December, as I mentioned, for your updates. You want to have your hazardous communication plan, this for you manufacturers. That's something with OSHA. You want to have your written SOPs, okay, your standard operating procedures. That's actually part of what gets submitted with your PMTA, and it's a whole other set of documentation separate from how you spell out your good manufacturing practices. And then you want to also have your general certificates of conformity. And this is a rule that the U.S. Consumer Product Safety Commission has, and I'll talk about them in just a moment when I wrap up this FDA. Now for retailers, you want to make sure you're only selling registered products. How do you know if they're registered? You ask your vendor, ask them. Of course, you can look it up on FDA also, but ask your vendor. You want to know if you're working with honest people, and you ask them in your questionnaire. So vet your suppliers. Have solid age verification procedures. I know eSig Intelligence has been discussing with FDA their technology to verify. I mentioned earlier, even where you're checking IDs to ensure no fake IDs, ask them, what's your address? What's your zip code? Can they tell you? If they can't tell you, they can't buy from you. You have your own policies. Write them down. Have a retailer training program in place, and then document your employee training on FDA compliance. Okay, so what should the industry do? Also, I recommend support your advocacy groups. SFATA really is out there fighting and representing the vapor industry. Support them. I mentioned earlier the meeting in June. If you can get to that would be great. And again, I'd be happy to forward you that information. So turning now to CPSC compliance, okay? I want to talk about this rule. Now, the rule came out actually, I think in 2016, but they only came out with the test method for verifying this rule not last month, but March. 4 years ago. So under the Child Nicotine Poisoning Prevention Act of 2015, it requires nicotine provided in a liquid nicotine container sold, offered for sale. So that means if you're just offering it on your website, manufactured for sale, or distributed in commerce to be in special packaging as defined by the Poison Prevention Packaging Act. And this is a separate requirement that's on top of the FDA's child-proof, packaging requirement. The only exception they have to this are these pre-filled pods, basically, containers that render the liquid inaccessible, i.e. pre-filled disposable cartridges, and those meant to be consumed at a vape or a vape shop. Now, in terms of defining what special packaging is, they define it as that for which the flow of liquid is so restricted that not more than 2 milliliters of contents can be obtained when the inverted open container is taken or squeezed once, or when the container is otherwise activated once. And I just threw in the regulation. Now, the test method to test if your bottle actually meets this special packaging requirement measures the force of the squeeze as if it were being done by a 5-year-old, right? So I know it's like, okay, well, how do you know? Maybe some of you have 5-year-olds. Maybe this doesn't even make sense to you, I mean, it doesn't quite make sense to me, but I mean, it literally makes sense, but the protocol doesn't really make sense. But they announced this method in March, and I was actually in touch with CPSC on Monday. because CPSC, they test for all kinds of things. They test for flammability levels in wearing apparel. They test for lead paint content on, on surfaces. Lots of CPSC testing must be done by a CPSC certified test lab. And so I wanted to know, for this particular test, does there also need to be a CPSC accredited test lab? Because they have a web page of accredited test labs, and when I looked up this test, there's no test lab. So they confirmed that no, there is not a certified test lab requirement for the testing. And I also asked them to provide me with a list of test labs who actually run this test. So for anyone who's interested, you're welcome to follow up with me about this as well. And I have cards up here with my contact information. So, in terms of CPSC compliance, in order to be compliant, vape manufacturers need to have this test performed to ensure their bottle restricts the flow as required under this law. And the GCC requirement, which the CPSC has for all kinds of industries, it's just a certification that you certify your bottles are in compliance with this law, this the poison prevention law. And so that's something. And they said, we're going to be out in the stores and we're going to be looking for companies, to verify their CPSC compliance. I can tell you, oftentimes when there's a new regulation, a new law that comes out, the agencies will do sort of a lot of immediate enforcement, and then it'll sort of peter off. But in terms of who they actually come looking for, it's anyone's guess. So, in terms of importers, importers beware, because it's not just about who's selling what, but they can also get you at the border. So all goods imported into the United States must comply with U.S. law at the time of importation. If they're not in compliance with U.S. law, then they get detained and or seized. But either way, the importer doesn't get the goods in, so then they can't get distributed and they can't get to your shops. Or your raw materials can't get to you and you can't produce to meet the orders that you promised to your retailers. So in the case of CPSC, if an imported e-liquid comes packaged with a dispensing cap, and CPSC made it a point to say this actually, that they presume that this applicator is intended to replace the original closure. And therefore that applicator must be this quote unquote special packaging design, be of that design, and pass the test to prove compliance with the law. I didn't go through the list to see which foreign factories there are. My guess is that there would be some in China. CPSC labs some are actually in almost every single country, depending on what the test is. But I don't know. But again, if we're talking about importers, we don't have to have the lab overseas. The factory can, or it would actually be probably the importer has the responsibility. So the importer would say, hey factory, what bottles are we using? What applicators are we using? Send them to me, and then you send them to the lab for the tests. And then once you get that okay, then you're like, all right, let's do the production. And let me just pause here, because I know sometimes when I talk to people in the industry about these any requirement for that matter, it's like, oh, what a pain in the butt. And, or, oh, is it really necessary? Or, oh, that's, I don't really want to do that. And a good example of this is when everybody had to put the nicotine warning statement at the top, right in the top 20% of every advertisement, warning, nicotine is an addictive chemical, right? But I haven't walked the show floor yet, but I can tell you, I was at one in Connecticut, and 70% of the booths have that at the top of their trade show. And I remember telling a client about this in 2017. They're like, Deanna, we really don't want to put that at the top of our thing. I said, listen, I know you don't, and nobody does, but everyone has to, because this is a highly regulated industry. And in a few years, it'll just be the normal thing that everybody does. And from what I've seen, and again, I haven't looked here, but it is becoming the industry norm, because it has to be the industry norm. So in any case, coming back to imports, again, U.S. Customs, if they find that it's not in compliance with CPSC, they can seize it based on what they consider the inadmissibility of the product, because it doesn't meet the rules. Now, some of you might be wondering, how does Customs even know who's manufacturing what? When you file your declaration with U.S. Customs, there's actually a box for the manufacturer's ID number. They already know who's manufacturing what and where, and they know who the importers are. So they can simply flag in their system, okay, we're going to pull, XYZ between this date range and just do a sample. So whenever customs does an audit, I've taken companies through customs audits, they take a random sample. They'll take like 6 over maybe, it depends how long the importer's been importing for. This industry is so young. So maybe they'll take, a sample of 6 customs entries over, a 2-year period, for example. And then they come to you and they make you provide all the documents. Sometimes they want physical samples as well. So they're looking, they're looking for this stuff. And actually, while I'm on the subject of importers, I also want to mention the tariffs. I mentioned the tariffs, and maybe if any of you have cable TV or not, you've heard about China tariffs. So China tariffs hit us. They hit us last year, and we had an opportunity into December to make a request. So here's how duties work. It's kind of like when you purchase something, you have to pay a sales tax. All goods imported into the United States are subject to the payment of a tax known as a duty, customs duties. And so customs duties, let's say it's 5%. That means for the value I'm importing, if I'm importing $100 of product, I've got to now pay $5 to US Customs, right? That's my 5% of the value of the good. What the China tariff thing is it says, okay, everybody with certain tariff numbers now has to pay, in this recent round, an extra 25%. And I know coils have been hit. There's different products in the industry that have been hit with this latest round that have gone up to 25. It had been 10% until May 10th, actually, so two Fridays ago. So anything, even if it were on the water, so in a vessel, on the container coming over, 12:01 a.m., it was now subject to this new rate of duty. And what we're able to do is we're able to ask for an exclusion to that additional duties. And so right now, with this additional tariff, we can ask that for some of these other accessories. But e-cigarettes got hit with the prior round, so we had until December to make those requests. They have had thousands of requests for different products. So they've actually announced 3 different sets of tariff numbers to exclude, but they haven't yet ruled on the e-cigarette tariff numbers. But we can all expect to see, and maybe some of you already have seen, prices going up, as soon as your next order, actually. All right, so coming back to CPSC, so what does this mean? Since FDA has its own packaging requirement on childproof packaging, FDA also said, look, if there's a change to your product, your registered product, like even a change to your bottle, it could render the product different and new. So, of course, the industry is concerned, well, if I comply with CPSC's new rule, now is my registered product no longer going to be considered compliant? And I can tell you, in terms of products, FDA not once has requested anybody explain to them what kind of bottle that they have. So FDA actually has no knowledge of who's got what kind of a bottle. And I'm not suggesting that you change the bottle to meet this requirement to the extent it doesn't, because I think a lot of the e-liquid bottles already do. Not all, a lot don't, but I also know a lot do. I mean, that's what I've heard anyway. So from the tests that I know of, which have been done. So we have risk coming from several different agencies. CPSC can find non-compliant products in a retailer store and pull them from the shelf and go after the manufacturer. US Customs can find your import non-compliant with CPSC requirements and seize the goods. So what they'll do is they'll say, you either need to export these, or we'll let you put them in a bonded warehouse and repackage. But again, if you're repackaging an e-liquid and that package isn't what's been registered with the FDA, where does that leave you? Because FDA could claim, that's the third point, oh, well, this is a new product, and, because you changed the bottle. So, to the extent there's a piece of operations which are not compliant, businesses need to decide what it can comply with, and what risk it can tolerate, if it determines it can't comply. At the end of the day, everybody in here is selling a product that's not even legally authorized to be sold. Everybody in here is taking a risk, myself included. I represent vape industry companies. If everything goes bye-bye, a big piece of my law firm goes bye-bye. We're all entrepreneurs. We're all at risk. So I understand how we've got to weigh the risk. Where are the risks? What risk can I tolerate? What makes sense? What do I want to do? And these are all business decisions, all of us have to make. And we're all here, I'm still hanging here with you guys. So we're in this together. Switching gears now to FDA and cannabis, okay? I wanted to announce that FDA is having a public hearing on May 31st, and people can still sign up to attend. It's going to be at their campus in Maryland. It's from 8 a.m. to 6 p.m. The point of this is because they want to obtain data and information regarding the safety, manufacturing, product quality, marketing, labeling, and sale of products that contain cannabis or cannabis-derived compounds, because of course everybody's like interested in CBD. Just to give a little bit of background around cannabis, we had our Agricultural Improvement Act of 2018, and this is known as the 2018 Farm Bill. It was signed in December of 2018, and it removed cannabis sativa and any part of the plant, hemp, from the Controlled Substances Act. It was intended to help to build up our hemp industry through the facilitation of production and marketing, but this AIA, the Agricultural Improvement Act, did preserve FDA's authority to regulate hemp products. And FDA is primarily concerned about things for human consumption, not so much animal consumption. So when it comes to things we consume, like food, they do have a series of things they refer to as what they consider generally recognized as safe, and it's just referred to as GRAS. And they specifically delineated, they actually published this information a few hours after the announcement of the 2018 Farm Bill in December, that they consider these three things as being acceptable for human consumption, and that's hulled hemp seeds, hemp seed protein, and hemp seed oil. So these can be legally marketed in human foods for use as food without approval, as a food additive, provided the products comply with all other legal requirements and do not make any disease treatment types of claims. So this would be, any health benefit. So do not make any therapeutic benefits. Where a marketing claim indicates that a product is intended for use in the diagnosis, cure, mitigation, treatment, or prevention of diseases, then the FDA treats it as a drug, so that it requires that product to undergo the drug approval process, which is more arduous than our PMTA. Now, the FDA position in food of other cannabis-derived properties is as follows. Because both, CBD and THC are active ingredients in FDA-approved drugs and were the subject of clinical investigations before they were marketed as foods or dietary supplements. So again, it's treated as a drug. It went through the drug approval process. FDA considers it illegal to introduce drug ingredients like CBD and THC into the food supply or to market them as dietary supplements. So I don't know, what other states everybody's in, but I know in January, in New York City, so my firms were based in New York City, constantly in the news, this cafe selling CBD coffee, this cafe selling CBD ice cream. Everybody had a sign, put up. They had no more CBD. They actually came and took the products out of their cafes. The stores were made to, put up signs selling, we're not selling these products containing CBD anymore. And I heard that this was happening in other states as well. Not all, of course, but in others. Of course, New York is very restricted. We only have 15. I think we only have 15 conditions that qualify for medical. And I'm a California native, and we've had medical since '96 or so. I mean, New York is really far behind, so depending on what state you're in, you might have a little more leeway. But again, FDA's position is you can't put it in food and sell it lawfully. And that remains their position to this day. So it's unlawful under the Food, Drug, and Cosmetic Act to introduce food containing CBD or THC into interstate commerce. So you can't sell it online and sell it into, in New York, we can't sell it to California, for example. They consider that unlawful. Or to market it or in dietary supplements, regardless of whether the substances are hemp-derived. Of course, it's the DEA's position is different, right? The DEA is like, hey, the DEA is focused on the plant itself, and they came out with a position saying, if CBD, whatever is extracted from the plant, that's from a part of the plant that is not considered covered under the Controlled Substances Act. So part of the definition of cannabis, of marijuana under the Federal Controlled Substances Act was that it excluded certain portions. So it excluded the stalks, for example. So their position was, if there's CBD, if there's something in the stocks aren't even part of the definition, it's exempt. But I mean, I don't know how many of you have seen the test lab results. I've seen several of stocks measuring CBD, and there's basically none in the stocks. So I know companies are saying, or we're saying, hey, we're getting it from the stocks. You know, I also know, and this is coming from large Canadian companies who are clients of mine, there really is no CBD in the stock. So, you know, again, how well do you trust, you know, your supplier? But this is FDA's position. It's a no-go. It's a no-go in food. And so they fully intend to take whatever action, whatever enforcement action is needed to protect the public health against companies illegally selling cannabis and cannabis-derived products that, one, may put consumers at risk, and two, are being marketed in violation of FDA authorities. And so, you know, because FDA had cracked down really, I guess this was in 2017 more, but they'd really been targeting companies selling online, claiming to have CBD, and that there was some health benefit, helped you with this, helped you with that. And understand, you know, that would even include where you have client testimonials on your website. So you don't even want to have those up there. So again, what should the industry do? You want to get your voices heard. If you want to go weigh in on cannabis and food, you have an opportunity to do that with the FDA. You do need to register. Educate your customers, manufacturers. Help teach your retail shops about the importance of age verification and oversight, product oversight. Retailers, educate your consumers on advocacy. Because, right, we vote in our elected officials. We have a voice. And quite frankly, we're not using our voice very well. If you have questions for me, an easy way to reach me. So there's an industry magazine, B2B Wholesaler. They are downstairs as well at the show. Some of you may know them. In July, we're rolling out a column. It's an Ask Deanna column. There's questions, there's answers. Questions are sent to me. In this issue, which is the May issue, on their table downstairs, I've got my email. It's deanna@mgtmedia.com. It's also up here. I'll walk you through it. Our April edition, we did a trial of it, and it's received a good response. So we're going to continue it with the July edition. And so if you guys have questions, business or legal, you know, do my best to answer them in the following edition. Also, if you'd like to learn more, I handed out this handout a little bit earlier, but I'll be hosting a webinar. It's a DIY vape and tobacco retailer training program. To the extent I have other FDA updates, I'll share those as well. And again, the coupon down here, just use the promo code CHAMPS and you can attend for free. And then to register, you literally type it in that way, and that'll take you to the Eventbrite page where you can register.